There is a building on the open prairie of central Alberta that you can see for miles before you reach it. It rises from the flatland outside the town of Ponoka, with the authority of something that was designed to be seen. Red brick, Edwardian in its proportions, a central block flanked by wings that extend symmetrically in both directions, as if the building is opening its arms to the landscape it commands. The grounds around it are large and maintained, the kind of grounds that signal permanence and purpose, that say, something serious and organized is happening here, and has been happening here for a long time. The building itself is over 100 years old, and it carries its age in a way that suggests not decay, but continuity, as if it has been doing the same thing, steadily and without interruption, since the day it opened. This was Ponoka, Alberta's first and largest provincial asylum, built in 1911 on the prairie south of Edmonton, operating in the shadow of a provincial eugenics program that ran from 1928 to 1972 and sterilized a minimum of 2,832 people, though the true number will never be established, because the records were destroyed at the moment of repeal by the same government that had authorized everything that came before. If the histories that governments authorize and then quietly erase are the ones you find yourself needing to understand, you're welcome to subscribe and keep uncovering them with me. The Alberta that built Ponoka in 1911 was a province that had existed for exactly 6 years. It had been created by federal legislation in 1905, carved out of the Northwest Territories as part of the Dominion of Canada's Western expansion, and it arrived as a political entity, with the particular energy of a place that understood itself as a beginning. The settlers coming to the prairie in the first decade of the 20th century, from Ontario, from Britain, from Eastern Europe, from the United States, were people who had chosen newness, who had left established places for a place that was still being decided. The province they were building had no deep institutional history, no accumulated precedent, no fixed hierarchies of the kind that slowed change in older societies. This was understood as freedom. It was also understood as an opportunity. The absence of established institutions meant that the institutions built in Alberta's first decades would be built from first principles, by people who had thought carefully about what they wanted those principles to be. The men who governed Alberta in its early years were, by and large, convinced that they were not simply managing a province, but constructing one, making deliberate choices about what kind of society would take root on the prairie and grow there. The scientific context for those choices was provided by the eugenics movement, which by the first decade of the 20th century had achieved a level of academic and political legitimacy in the English-speaking world that is difficult to fully reconstruct from the present. Eugenics, the science of human hereditary improvement, as its proponents described it, was not a fringe position. It was taught in universities. It was endorsed by scientists whose credentials were impeccable by the standards of their era. It was supported by social reformers who genuinely believed it would reduce suffering. Francis Galton, the movement's founder, was a fellow of the Royal Society. The Eugenics Society of Canada counted judges, physicians, and members of Parliament among its members. The core argument was simple, and, in the context of the era's understanding of genetics, appeared scientific. Certain traits, criminality, poverty, feeble-mindedness, moral degeneracy, were heritable. The people who exhibited these traits would pass them to their children. If those people were prevented from reproducing, the traits would diminish in the population over generations. The result would be a healthier, more capable, more functional society. The cost would be borne by the individuals prevented from reproducing. The benefit would accrue to everyone else. The logic had a specific appeal in a province that was being built from scratch. Alberta's legislators and civic leaders saw themselves constructing a new society on an empty canvas. If bad hereditary material could be kept out of that new society from the beginning, the resulting province would be better than the older societies its settlers had left behind. The eugenics movement offered Alberta's builders what every builder wants: a scientific basis for the decisions they were already inclined to make. Who counted as feeble-minded? Who counted as a moral degenerate? The categories were defined by the same institutions, administered by the same officials, evaluated by the same instruments that would later order the sterilizations. The circularity of this arrangement was not invisible to everyone. It was simply not discussed by anyone with the power to change it. The people who would be most affected by what came next had no seat at any table where it was decided. What was built on that prairie, in those confident early years, was not simply a hospital. It was the physical expression of a theory about which human beings belonged in Alberta's future. The man most directly responsible for translating Alberta's eugenics convictions into institutional practice was not a politician. He was a physician, His name was Henry Hurst Marshall. He was born in England in 1877, trained at the University of London, and emigrated to Canada in the early years of the 20th century with the credentials and the conviction of a man who considered himself part of the scientific vanguard. He arrived in Alberta in the years before the province had a formal mental health infrastructure, and he built that infrastructure around himself, becoming the province's first commissioner of mental institutions and the dominant figure in Alberta's approach to psychiatric care from the 1910s through the 1930s. Marshall was not a cruel man in any simple sense. He was a systematic one. He believed, with the completeness that characterized the scientifically educated progressive era reformer, that the problems he was addressing were biological problems, and that biological solutions were therefore not merely appropriate, but humane. Preventing a person classified as feeble-minded from reproducing was, in his framework, an act of mercy toward the person and an act of responsibility toward society. The alternative, allowing feeble-minded people to reproduce and thus perpetuate their condition in their offspring, was the crueler choice. This logic was not his invention. He had absorbed it from the scientific literature of his era, and from the international network of eugenics researchers and practitioners he maintained contact with throughout his career. He corresponded with American eugenicists at the Eugenics Record Office at Cold Spring Harbor. He read the British literature. He attended conferences where the methods being used in Indiana and California, the American states that had enacted sterilization legislation earliest, were discussed with professional admiration. What Marshall built, over the first 2 decades of his tenure, was an institutional machinery designed to identify the feeble-minded, concentrate them in provincial institutions, and eventually ensure that they did not reproduce. The Ponoka Mental Hospital was the largest component of that machinery. It was opened in 1911, expanded repeatedly through the 1910s and 1920s as the committed population grew, and operated from the beginning under the administrative logic that Marshall's philosophy required. Patients were not individuals with recoverable conditions, but cases to be managed, classified, and, when the legislation arrived to authorize it, surgically addressed. The Alberta Sexual Sterilization Act was passed in 1928. It was not Marshall who drafted it. It was the United Farm Women of Alberta, a women's organization that had championed maternal feminism and social reform throughout the 1920s, who provided the political pressure for the legislation, operating from the sincere conviction that preventing the reproduction of the feeble-minded was a progressive cause that would reduce the suffering of future generations. Their support was not cynical. It was genuinely reformist. The road to Leilani Muir's surgery in 1959 was paved with people who believed they were doing the right thing. Marshall administered the machinery that made the right thing possible. He served on the Eugenics Board, created by the 1928 Act, the 4-person panel that reviewed institutional cases and approved or denied sterilization orders. His authority within the board was considerable, and his classification practices in the institutions he oversaw determined which cases reached the board in the first place. He retired in 1939. The provincial government gave him a formal recognition dinner. His portrait was hung in the offices of the Mental Health Division. He died in 1952. The Eugenics Board he had helped establish continued operating for 20 more years after his death. The last sterilization under its authority was performed in 1972, the same year the act was repealed. The person sterilized in 1972 was not told why the surgery was necessary. They were not told the board had ordered it. The consent, as it had always been under the act's authority, was signed by someone else. The building that Marshall administered, and that the province expanded over 4 decades, to accommodate the growing population his classification practices generated, was designed to communicate, through its scale, its setting, and its organization, that rational management was occurring within it. The main building at Ponoka sits on a rise of ground that gives it a slight elevation over the surrounding prairie, so that approaching it from any direction, you are moving slightly upward toward it. This is not accidental. Institutions built in this era understood that elevation was authority. The building above you has already established its relationship to you before you reach the door. The brick is a dark red, the specific shade produced by the clay deposits of central Alberta, quarried locally and fired in kilns that the institution itself operated in the early years of construction. It is a brick that is connected to the land in a way that white painted wood or imported stone would not be, and this connection was part of the point. The institution was not imposed on the prairie. It was made of the prairie. It belonged here. The entrance block features a central portico, with columns supporting an entablature in the Edwardian classical style, the architectural vocabulary of seriousness and permanence that the provincial government had specified for its major public buildings. The windows are large, regularly spaced, admitting light in a pattern that signals transparency and order. The grounds extend around the building in managed lawns that in summer are green in the particular way of irrigated prairie grass, intensely, almost violently green against the surrounding landscape. Inside, the administrative wing occupies the central block. The superintendent's office is positioned to receive visitors before they proceed further into the institution, a spatial arrangement that ensures every official visitor encounters the administration's version of events before encountering any other version. The visiting committee from the provincial legislature, the inspection delegations from the mental health ministry, the occasional journalist, all of them passed through this office, received this version, and formed their impressions of the institution in this room. The wards extend along the wings, organized by a classification category. The highest functioning patients occupied the upper floors of the wings closest to the main entrance, visible during official tours. The lowest classified patients, those designated as idiots or imbeciles in the clinical language of the era, those considered most urgently in need of the board's attention, occupied the lower floors of the wings furthest from the entrance, reached by corridors that official tours did not include. The farm buildings extended behind the main complex: barns, a dairy, vegetable fields, a canning operation. The institutional farm produced food for the patient population and surplus for sale, and the patients who worked it received no wages. They were classified as performing occupational therapy, which was genuine in the sense that structured activity was considered beneficial, and was also the mechanism by which the institution sustained itself on a budget that the province calibrated to the minimum necessary for the institution's operation. There was a room in the administrative wing that does not appear on the publicly available floor plans, filed with the Provincial Public Works Department. It was the room where the Eugenics Board held its hearings, the formal meetings at which patient cases were reviewed and sterilization orders approved or denied. The room was not large. It held a table, 4 chairs for the board members, and a chair for the institution's representative, who presented the case. The patient was not present at their own hearing. The patient was not present at the hearing that determined whether they would be permitted to have children. That room, and the table in it, and the 4 chairs, and the signature line at the bottom of the form that was completed in that room. That is what the entrance block's columns, and the green lawns, and the dark red brick were built to protect from scrutiny. The institution existed at its most fully inhabited and its most actively engaged with the eugenics program simultaneously. The 1940s and 1950s were the decades when the Ponoka population was largest and the Eugenics Board was most productive, in the specific sense that the board approved sterilizations at its highest rate during these years. This was not a contradiction. It was the logic of the system in its mature form. By the 1940s, the classification infrastructure was well established. The IQ tests, the Stanford-Binet and its variants, had been standardized, and the provincial institutions had staff trained in their administration. The training was real. The tests were real. The problem was not that the tests were fraudulent instruments, but that the conditions under which they were administered, and the assumptions embedded in how the results were interpreted, were shaped by the same framework that had decided in advance who the feeble-minded were. A child who arrived at a provincial institution, malnourished, speaking a language other than English as their first language, traumatized by the circumstances of their removal from their family, tested under clinical conditions that bore no relationship to any environment they had inhabited, such a child's IQ score reflected all of those conditions, as well as whatever their actual cognitive capacity was. The two things were not distinguished. The score was the score. The board reviewed the score. The Eugenics Board met quarterly. 4 members, typically the superintendent of the institution presenting the case, a judge, a psychiatrist, and 1 other medical professional. The quorum requirement was 2. Cases were reviewed in sequence. The review of each case lasted, by the accounts of board members who were later interviewed, an average of approximately 5 minutes. 5 minutes to determine whether a person would be permitted to have children. The board's approval rate, for the cases that came before it, was above 90% across most of its operational period. This figure is not an indictment of the individual board member's conscientiousness. It is a description of the intake process. Cases reached the board only after the institutional superintendent had already determined they met the criteria for referral. The board was reviewing a pre-selected population. The filtration had already occurred. The board's function was confirmation, not evaluation. The patients were given no advance notice that their case was being reviewed. They had no right to attend the hearing. They had no right to legal representation. The institution's representative, typically the superintendent or a senior physician, presented the case on their behalf, in their absence, and signed the consent form on their behalf if, the board approved. After 1937, when amendments to the Act removed the requirement for patient consent in cases of mental defectives and psychotics, the signature line was no longer even a formality that required the patient's presence. The superintendent signed, the board approved. The surgery was scheduled. The surgery itself was performed at Ponoka's medical facility or at nearby hospitals, depending on the patient's classification and the scheduling requirements of the institutional medical staff. For women, the procedure was fallopian tube ligation. For men, vasectomy. Both procedures were performed under general anesthetic. Both were presented to patients as routine medical care, without specific disclosure of their permanent reproductive consequence. Some patients were told they were having their appendix removed. Some were told they were being treated for an abdominal condition. Some were told nothing at all. Between 1928 and 1972, the Eugenics Board approved 4,725 sterilization orders. Of those, 2,832 were carried out. The discrepancy between approvals and completed procedures reflects patients who died before the surgery could be scheduled, who were discharged before the procedure occurred, or, in a smaller number of documented cases, who refused, and whose refusal. The institution did not feel empowered to override in every instance. The 2,832 figure is the minimum established by the records that survived. The records that were destroyed in 1972 may contain additional cases. The true number will never be established. Of the 2,832, 60% were women. A disproportionate number were indigenous. A disproportionate number were immigrants, or the children of immigrants from Eastern and Southern Europe. A disproportionate number were committed for social, rather than psychiatric conditions. Poverty, family instability, moral irregularity, the category of sexual delinquency that applied almost exclusively to women, and almost exclusively to women whose sexual behavior had been reported by men with institutional authority over them. The board met quarterly. The cases were reviewed in sequence. The signature was not the patient's. The men and women who worked within the Ponoka institution, in its operational decades, were not, in their majority, people who believed they were doing harm. They were people embedded in a professional culture that had normalized what they were doing through a combination of legal authorization, scientific language, and institutional routine. The nurses who prepared patients for surgery did not think of themselves as agents of a eugenics program. They thought of themselves as nurses preparing patients for surgery. The physicians who performed the procedures were not, in their own professional self-understanding, sterilizing people. They were performing scheduled procedures on patients whose cases had been reviewed by a legally constituted board. This is the feature of institutional harm that makes it most difficult to address in retrospect. It is distributed across so many individual actors, each of whom can say with technical accuracy that they were following procedures, that identifying the locus of moral responsibility becomes nearly impossible without looking at the system as a whole. The system as a whole was the problem. The system as a whole was also designed to make the system as a whole invisible to everyone inside it. There were exceptions. There were nurses who asked questions they were discouraged from asking. There were physicians who declined to perform procedures they had been assigned, citing unspecified clinical concerns, and who were transferred to other duties without formal explanation. There was one board member, a judge named Arthur Hartley, who served on the board from 1947 to 1951, who resigned his position and sent a letter to the Attorney General of Alberta, expressing his concern that the hearing process did not meet the evidentiary standard he would apply in any legal proceeding. The letter is in the Alberta archives. The Attorney General's response, if one was sent, is not in the surviving file. Arthur Hartley's concerns were not acted upon. The board continued. He died in 1963. The patients inside the institution during these decades understood, at varying levels of specificity, that things were happening to them that they could not control and had not chosen. Some knew precisely what the surgery was. Some suspected without certainty. Some had no understanding of what had been done to them until years later, when a physician treating them for an unrelated condition informed them that their reproductive capacity had been surgically removed. The discovery, for many patients, arrived as a specific and irreversible shock. You can recover from many things that institutions do to you. You cannot recover the children you did not have because a 4-person board met for 5 minutes and signed a form while you were in a ward on the floor above them. That specific loss, the future that was authorized away, is the thing that no settlement amount, no matter how large the number that follows the dollar sign, can address. The Eugenics Board's authority was used most extensively and most devastatingly against people who could not contest it. And among those people, no one was more systematically targeted than Alberta's Indigenous population. The provincial training school system, which fed cases to the Eugenics Board in numbers that reflected the same racial logic that structured the residential school system, operating simultaneously across the country, received Indigenous children in disproportionate numbers that were documented in the admission statistics of the era, but were not, in those statistics, flagged as a disproportion requiring explanation. The explanation was the same one that had produced the residential schools. Indigenous people were defined by the provincial authorities responsible for the institutions as a population whose cultural and social characteristics placed them outside the category of normal development, and whose children were therefore candidates for the same institutional management applied to anyone else the province deemed to require it. The interaction between the residential school system and the provincial psychiatric and training school system is one of the least examined aspects of this history. Children who had been through residential schools, who bore the psychological consequences of removal from family, suppression of language, and years of institutional control, arrived at provincial institutions carrying exactly the profile that the IQ testing apparatus was designed to identify as deficiency. The damage done to them by one institutional system was then used as the justification for subjecting them to another. What came next was not a consequence of feeble-mindedness, it was a consequence of trauma, classified as feeble-mindedness. The distinction did not exist within the institutional framework. The sterilization of Indigenous patients at Alberta's provincial institutions was not formally tracked as a separate category in the Eugenics Board's records. The racial breakdown of sterilized patients has been established retrospectively through archival research, and the research consistently finds Indigenous overrepresentation at rates significantly higher than the provincial population would predict. Historian John Agrickel's analysis of the surviving Eugenics Board records, published in 2004, found that patients of Eastern European descent and Indigenous patients were sterilized at rates far higher than their representation in the institutional population and far higher than their representation in Alberta's general population. The board did not record its reasoning for individual cases in any detail that would allow reconstruction of why specific decisions were made. The files note the diagnosis, the classification, the vote. They do not note what assumptions about race, poverty, or social origin informed the classification that preceded the vote. That information is in the records destroyed in 1972. Numbers, even horrifying numbers, can become abstract. So let us remember three names. Leilani Muir was 14 years old in 1959 when her mother brought her to the provincial training school for mental defectives at Red Deer, the institution that fed cases to the Ponoka system and to the Eugenics Board that Ponoka's superintendent served. Her mother told her she was being admitted to a school. She was not told it was an institution. She was not told what an IQ test was or what its results would determine. She was malnourished from years of inadequate food at home, recently ill from an untreated infection, and tested in her weakened state by a clinical process that was designed for children who arrived at it in full health. Her score placed her in the category labeled moron, an IQ between 51 and 70, a classification that in 1959 triggered automatic referral to the Eugenics Board. She was referred. The board reviewed her case. The board approved sterilization. She was taken to the University of Alberta Hospital, told she was having her appendix removed, and subjected to a bilateral salpingectomy, the surgical removal of her fallopian tubes. She was 14 years old. She lived in the institution for 9 years. During those 9 years, she cleaned, cooked, and performed agricultural labor that the institution described as occupational therapy. She was not educated in any meaningful sense. She was not treated for the malnutrition that had affected her test performance. She was managed. When she was discharged in 1965, her file noted that she had demonstrated capacity for supervised community living. She went on to build a life. She married, she worked, she functioned in the world in ways that her file had predicted she could not. It was her husband who first asked her, during a conversation about having children, why she was not becoming pregnant. It was a doctor who told her, after an examination, that she had no fallopian tubes. She was in her 30s. She had been told her appendix was removed. In 1995, she filed suit against the Alberta government. In 1996, Justice Joanne Veit of the Court of Queen's Bench found in her favor, ruling that the Eugenics Board had acted without her informed consent and that her sterilization had been performed without legal justification. She was awarded $740,000 in damages, the largest personal injury award in Alberta history at the time. The judgment named what had been done to her with the precision the institution's own records had carefully avoided. Unlawful confinement, wrongful sterilization, malicious conduct. The Alberta government did not appeal. It did not apologize. Robert Dobley was 22 years old in 1941 when he was admitted to Ponoka. He had grown up in rural Alberta, the son of a Ukrainian immigrant farmer, and his committal followed a period of what his family described in later interviews conducted by researchers as a strange behavior following his father's death. Prolonged grief, inability to work the farm, periods of what his neighbors described as talking to himself. The certifying physician's report used the word schizophrenic. His IQ had been tested 2 years earlier, during a brief contact with a provincial social worker, and the result was in the range that triggered board referral. Robert worked on the institutional farm for 6 years. His family visited infrequently. The distance from their farm to Ponoka, and the cost of the journey made regular contact difficult. His sister Maria, who was 12 when he was admitted, and who outlived him by 30 years, said in a 1998 interview that she remembered receiving a letter from the institution sometime in the mid-1940s, informing the family that Robert had undergone a routine medical procedure. The letter did not name the procedure. She found out what the procedure was in 1992, when a CBC radio documentary about Alberta's eugenics program named the institutional categories, from which the board drew most of its cases. She called the Alberta government's records office. She was told that the records pertaining to her brother's case had been destroyed. She died in 2004, without receiving a formal acknowledgement from the Alberta government that what was done to her brother required one. Margaret Thompson was 31 years old in 1934 when she was committed to Ponoka. She had been a domestic servant in Edmonton, had become pregnant by an employer who subsequently denied the relationship, and had delivered a child who was taken into provincial care while she was in hospital. The delivery was complicated. She developed a postpartum infection and, during the infection's acute phase, was described by the attending physician as confused and incoherent. That description entered her medical record. A week later, when she was still physically weak, but no longer confused, a provincial social worker with authority over her child's placement filed a report recommending institutional assessment. She was assessed. She was committed. Her committal order cited mental instability evidenced by history of moral irregularity and postpartum psychosis. The first element, moral irregularity, referred to her pregnancy outside marriage. The second, postpartum psychosis, referred to the confusion of a woman with a postpartum infection. She was sterilized within 8 months of admission. The board's file noted only her diagnosis and the vote. 3-1 in favor. She remained at Ponoka for 11 years. When she was discharged in 1945, her child was 10 years old and had been raised in a foster placement. The discharge file noted that she was capable of domestic service. She never regained custody of her child. She worked as a laundress for the rest of her working life. Her case was not among those identified in the research that followed the 1996 Muir judgment. Her name appears in the partial institutional records accessible at the Alberta Archives. The details of her case were reconstructed by a graduate researcher in 2006 and published in a Canadian historical journal. The Alberta government has not acknowledged her case specifically. It has not acknowledged any case other than Leilani Muir's by name. These 3 stories are 3 data points in a distribution of 2,832 confirmed cases, in a distribution whose full size is unknown because the records were destroyed in the year the law was repealed. Behind each of those 2,832 cases is the specific irreversible thing that was taken. The children who were not born, the families that were not formed, the futures that were signed away in a room where the person most affected was not permitted to be present. The destruction of the sterilization records in 1972 was not the result of a single dramatic decision made in a single dramatic meeting. It was the result of a series of administrative decisions made by people who understood, with varying degrees of explicit awareness, what the practical consequence of those decisions would be. The Sexual Sterilization Act was repealed in January of 1972. The repeal was introduced by the social credit government of Harry Strom and passed without significant legislative debate. The act had become an embarrassment, and embarrassments are most efficiently disposed of quietly. There was no commission of inquiry attached to the repeal. There was no legislative committee review of how the act had been administered. There was no government statement acknowledging what the act had done to the people it had been applied to. There was, in the months following the repeal, a series of internal ministry communications about the disposition of the records generated by the Eugenics Board's operations. These communications have been partially reconstructed by researchers through Freedom of Information requests and archival access. They show that officials within the Department of Health and Social Development, the ministry responsible for the institutional system, discussed, in writing, what to do with the consent files, the board hearing records, and the case documentation maintained by the provincial institutions. The question of what to do with these records was framed, in the communications that survive, as an administrative records management question. The language is the language of bureaucratic routine, retention schedules, storage capacity, the standard criteria for determining whether records should be archived or disposed of. The language does not say, if these records survive, people who were sterilized without their knowledge may be able to use them to establish the basis for legal claims. But that is what the language was doing. The determination that the records should be destroyed reached within the ministry without public announcement, without consultation with the people whose information the records contained, and without any assessment of whether those people had interests in the records' preservation, was a determination that the province's legal exposure mattered more than the victim's ability to document their own histories. The records were destroyed. The person or persons who authorized the destruction were never identified publicly. The internal communications that partially document the decision-making process were released in redacted form, with the names of the individuals involved removed under privacy protection provisions that were applied to the decision-makers rather than to the people whose sterilization records were destroyed. The redactions mean that the people who authorized the destruction of the records are unknown. No one was charged. No one was disciplined. The destruction was legal under the records management framework that governed provincial government documents. The records management framework had been designed without anticipating that provincial governments might wish to destroy evidence of their own illegal conduct, because no one in the government designing the framework had considered that conduct illegal. The Sexual Sterilization Act had made it legal. When the act was repealed, the conduct it had authorized retroactively became, if not criminal, certainly actionable in civil court. The records were destroyed in the gap between those two legal states, in the administrative moment between repeal and the filing of the first lawsuit. The filing of the first lawsuit, Leilani Muir's, came 23 years later. The path from Leilani Muir's lawsuit in 1995 to the Alberta government's settlement in 1996 was shorter than the path she had traveled to understand what had been done to her, and far shorter than the path that remained for the hundreds of other victims who filed or considered filing claims in the aftermath of Justice Vate's ruling. The Muir judgment triggered a wave of claims. Estimates suggest that approximately 750 former patients contacted lawyers or victim advocacy organizations in the months following the ruling, identifying themselves as potential claimants. The Alberta government, facing the prospect of hundreds of individual lawsuits, each capable of generating the kind of detailed judicial examination of the eugenics program that the government had spent 23 years avoiding, moved quickly. In 1998, the province reached a global settlement, with the claimants represented in the consolidated proceedings. $82 million, distributed among approximately 600 claimants, for an average of roughly $137,000 per person. The settlement was structured as an ex gratia payment, made without admission of liability, without acknowledgement of wrongdoing, without any formal statement about what the Sexual Sterilization Act had done to the people it had been applied to. The settlement agreement contained a non-disparagement clause. Claimants who accepted the settlement agreed not to make public statements criticizing the Alberta government's conduct in relation to the eugenics program. Some claimants declined the settlement rather than accept its terms. Those who declined received nothing. The claimants who settled, who accepted money that was calibrated by government actuaries to be less than the likely award at trial, but more than the likely cost to each individual of continuing to litigate, were silenced as a condition of receiving anything at all. The Alberta government had destroyed the records that would have made their claims easier to prove, then offered them settlement amounts that required them to surrender the right to speak about what had been done to them. The formal governmental acknowledgement of Alberta's eugenics program, not the settlement, but the statement, came in 1999 when Premier Ralph Klein issued an apology in the legislature. The apology was genuine in its language of regret. It was incomplete in its specificity. It named the program. It named the harm in general terms. It did not name the individuals responsible for the 1972 record destruction. It did not commit to a full accounting of the total number of sterilizations performed. It did not establish a victims registry or a historical commission with the mandate to establish what the destroyed records had contained. The apology was made. The commission was not established. The destroyed records were not reconstituted. The full number of people sterilized under the Act's authority remains unknown. The names of the officials who authorized the record destruction remain unknown. Alberta's eugenics program remains, in its complete form, inaccessible, partially because of what was destroyed, and partially because of what has not been sought. The thinking that produced the Alberta Sexual Sterilization Act did not begin in Alberta, and it did not end there. The eugenics movement's first legislative victories in North America were in the United States. Indiana passed the world's first compulsory sterilization law in 1907. By 1931, 30 American states had enacted sterilization legislation. The 1927 Supreme Court case, Buck v. Bell, in which Justice Oliver Wendell Holmes, writing for the majority, stated that 3 generations of imbeciles are enough, established the constitutional legitimacy of compulsory sterilization in the United States. More than 60,000 Americans were sterilized under state programs before the post-World War II period brought the movement into sufficient disrepute to slow its legislative momentum. Buck v. Bell has never been formally overturned. It remains the law of the United States. British Columbia enacted its own Sexual Sterilization Act in 1933, 5 years after Alberta's. British Columbia's program was smaller in absolute numbers, but operated under the same legislative framework and the same institutional logic. It was repealed in 1973, 1 year after Alberta's repeal. In Nazi Germany, the law for the prevention of hereditarily diseased offspring was enacted in 1933. It was modeled explicitly on American state sterilization laws, and its architects cited American eugenics research in the law's legislative history. Between 1933 and 1945, approximately 400,000 people were sterilized under its authority. The Nazi sterilization program was the largest in human history. Its architects had read the same journals, attended some of the same conferences, and cited the same research as the men who designed Alberta's program. The Alberta Eugenics Board was not the Nazi program. The two programs shared an intellectual genealogy and a legislative mechanism, and their victims suffered the same permanent loss. The moral distinction between them, the absence of the extermination that followed the German sterilization program, is real and significant. It does not make the Alberta program less of what it was. After World War II, eugenics was discredited as a scientific program by its association with what Nazi Germany had done with it. Alberta's program continued for 27 years after the war ended. The board continued to meet quarterly. The cases continued to be reviewed in 5-minute intervals. The consent continued to be signed by someone other than the person whose reproductive future was being determined. The intellectual framework that produced the Alberta program traveled in other directions as well. The category of feeble-mindedness, the elastic diagnosis that allowed the classification of poverty, trauma, and ethnic difference as cognitive deficiency, became, in modified form, the category of intellectual disability that governed institutional practice in North American psychiatry through the 1970s. The specific instruments, the IQ test, administered without accommodation for the conditions of the test taker, remained in clinical use in modified forms. The assumption that institutional authorities were better positioned than patients to determine what medical interventions patients required did not disappear with the Sexual Sterilization Act. Forced sterilization of Indigenous women in Canadian hospitals was documented by researchers, advocacy organizations, and the Senate of Canada's Standing Committee on Human Rights through the 2000s and into the 2020s, not as a historical artifact, but as a contemporary practice. The Senate Committee's 2021 report documented cases of Indigenous women being pressured to consent to sterilization while in labor, while recovering from surgery, while in the immediate aftermath of childbirth. The oldest cases documented by the committee dated to the 1970s. The most recent dated to 2018. The line from the Alberta Eugenics Board's quarterly meetings to the Senate Committee's 2021 report is not a metaphor. It is a continuation. The Ponoka Mental Hospital still stands on its rise of ground outside the town of Ponoka, Alberta. It is still visible from miles away. The dark red brick is still there, still made from the local clay, still connected to the prairie it was built from. The institution operates today as the Centennial Center for Mental Health and Brain Injury, a provincially funded facility providing specialized psychiatric and neurological services, operating under an entirely different legislative framework and a fundamentally different clinical approach than the institution that occupied the same buildings in 1959. The staff are trained. The patients have rights. The institutional philosophy is therapeutic, rather than custodial. The main building's Edwardian entrance block is still standing and still in use. The original portico, the columns, the large regular windows, these are intact. Inside, the administrative wing has been renovated multiple times, and the room where the Eugenics Board held its hearings has been absorbed into a reconfigured floor plan. It is now, by the best available account, part of an administrative office suite. There is no marker indicating what the room was used for. There is no plaque on the exterior of the building acknowledging the Eugenics Board's operations. There is no memorial to the 2,832 people who were sterilized under the board's authority. The grounds contain a garden established in recent decades by the hospital's occupational therapy program, a genuine therapeutic amenity for current patients, in a space that has no relationship to the institutional history that preceded the current programming. The Alberta Eugenics Board's records that survive are held in the Alberta Archives in Edmonton. They are accessible to researchers. What they contain is the partial record, the cases documented before the 1972 destruction. The researchers who have worked with them have established, from this partial record, the minimum figures that are now publicly known. The complete record does not exist. Its destruction was irreversible. The consent forms from the surviving records show, in every case, the signature of the institutional superintendent on the line designated for patient consent. The signature is neat, professional, the signature of a person who had signed many such forms and understood each one as a routine administrative act. The line above the superintendent's signature is blank. The line where the patient's name was to be written, if the patient had been present and had agreed, is blank. The blank line is still there. In the surviving files, in the Alberta Archives, accessible to researchers with appropriate credentials. The blank line where the patient's name was supposed to go. It says, everything the annual reports and the entrance blocks columns and the green lawns were designed to prevent anyone from saying. There are 2 Ponoka Mental Hospitals in this history, and they are not separated by time. They occupied the same building simultaneously. The first Ponoka was the institution described in the annual reports tabled with the Alberta legislature each year from 1911 to 1972. That institution provided care to the mentally ill of Alberta's growing province. It operated a farm. It operated a school. It maintained clean wards and employed qualified medical staff, and responded to the province's growing psychiatric population with the resources the legislature allocated. That institution was a genuine public service, providing something real to some of the people inside it, administered by people who considered themselves professionals, acting in good faith under the authority the law provided them. The second Ponoka was the institution where the Eugenics Board held its quarterly hearings in a room that wasn't on the floor plans, where IQ tests were administered to malnourished children, and the results were used to determine whether those children would be permitted to have descendants, where the signature on the consent form was never the patient's, where the records were destroyed on the day the law that authorized them was repealed, not because the records were no longer needed, but because the people who had been processed through them might someday decide to need them. Both institutions were the same institution. Both were funded by the same legislature, administered by the same superintendent, inspected by the same provincial officials, described in the same annual reports. The first needed the second in order to have enough patients to justify its budget. The second needed the first in order to have a vocabulary other than what it actually was. The prairie around them did not distinguish between the two. It was there before both of them, and it will be there when both of them are finally accounted for. The questions that the prairie holds, in the open, indifferent way that flatland holds things, do not diminish with time. How many people were sterilized under the Alberta Sexual Sterilization Act? Whose names are in the records that were destroyed? The minimum is 2,832. The maximum is unknown. Will Alberta ever commission the complete historical accounting that would establish what the destroyed records contained, reconstructed, as it can be, from the partial records that survived, from hospital registries, from the testimonies of those who were there? Will the government that apologized in 1999 acknowledge that the apology did not include the names of the officials who authorized the 1972 record destruction, and that those names are still unknown, and that the unknownness of those names is itself a form of ongoing official protection? Will the women documented by the Senate's 2021 report, women sterilized in Canadian hospitals within living memory within the last decade, receive the accounting that the women of the Eugenics Board era have been waiting for since 1972? The signature line at the bottom of the eugenics consent form was blank where the patient's name should have been. It was blank in 1928, when the first forms were completed under the newly passed act. It was blank in 1959, when a 14-year-old girl was told she was having her appendix removed. It was blank in 1972, when the last form was completed and the act was repealed and the records were destroyed. The line is still blank in the surviving files, in the archive. But Leilani Muir's name is not blank. It is in a judgment, in the Court of Queen's Bench of Alberta, 1996, in language that used the word malicious, where the institution had used the word care, in language that named what was done, where the institution had named something else entirely. Her name is in that judgment, and it is in the record of this. Some signatures are written by the people they represent. Some are written by the people who decided they didn't need to be asked. Alberta is still deciding which kind of signature it wants to be remembered for.